Hello everyone. Today we're going to talk about probate. What is it? Why do we need it? When do we need it? What can we do to avoid it? So we have several videos out there about estate planning, the benefits, how they work. Have a look. We have a YouTube channel now, so you can subscribe to that, or you can go on our Facebook page where we have our videos listed. But today we're going to talk about probate. What is probate? Probate is usually triggered when someone passes. Is probate needed every time someone dies? No. It's usually triggered by real property. So if the person who passed does not have an estate plan in place, it depends on the type of ownership of real property. For example, if you own it as a joint tenant with the right of survivorship and you are the first one to die, there will be no probate. But if you are the second person to die and there's nothing else in place, yes, you may need a probate. Also, sometimes people don't have beneficiary listed on their financial accounts, such as life insurance. If you have a life insurance that it's over, let's say, 100,000, and it does not have a beneficiary listed, there is a chance that upon your passing, your beneficiaries, your heirs, will have to start a probate. So, what is probate? Probate is the legal process through which we ask the courts, hey, please allow us to distribute the assets. How does it work? Well, a loved one, an heir, a child, or a family member will have to go, usually hire an attorney and begin the process. So, I'm an estate planning attorney. I handle probates. This is what I would do. This here is a petition for probate, okay? So let's read through it and see what kind of information one would need to initiate a probate. It says the district court of, usually is the county where the person passed, in the matter of the estate of the person's name. The title is Petition for Probate of Will, Appointment of Executor, and Determination of Heirs at Law, Devisees. One thing I should mention about probate at this time is that probate is a public process, meaning that anyone can be in the courtroom when we are discussing a probate case. And also these pleadings, this petition is filed with the court records, of course, that often are online, and anyone can pull up this information. So let's talk about why you wouldn't want that to happen to you. Some of the information in the petition that is required, it says this is the deceased person, their name, their date of death, where they died, where domiciled. If they died testate or intestate, meaning if they have a will or no will. So basically it's worth mentioning here, if the person only had a will, if you only have a will, this will have to be filed, okay? A will does not avoid probate. Common misconception, you need something more than that. A trust, or maybe a transfer on death deed or something like that. This is the will. The will, again, becomes public record. It will be filed of record and anyone can pull it up off the internet. Again, might not be the kind of information you want out there. The petitioner thinks this is the last will and testament. There was no duress involved. Then the petitioner is asking to be appointed as personal representative. What is a personal representative? The personal representative is the person who is appointed by the courts to be in charge of administering the estate. What does that mean? That means we need someone who has the authority, the legal authority, to close bank accounts, to collect assets, to sell property. For example, we need someone to sign the deed if property has to be sold. Let's go back to the petition. We have the names and the last known addresses of the heirs. Usually the heirs are kids. If there are kids, if there are no kids, it goes on in the family. It could be cousins, parents, grandparents, and so on. Some other parts of the petition include what, and not everyone includes that, it could be kept off, but a list of assets that the person who passed had. They had a home at this address, they had some mineral interest, there's a life insurance, there's some stock, then some legalese. Then we're asking the court to allow us to appoint a personal representative, and we're asking the court to set the matter for hearing. So basically there will be a hearing when the judge would actually sign the letters of administration, giving someone authority to act on behalf of the estate. And then the petitioner would sign this in front of a notary, will file it. It's the filing fee is $214.14, so $200 just to file it. Then we have to publish a few times. If nobody's contesting, what can people contest? They can contest the will. They can say, no, that's not valid, or they can say they were under duress. They can contest the distribution. They can say, oh, I'm also a child. You hear those stories when someone dies, people come and say, he was my dad, she was my mom, I want to share. So if a probate is not contested, the simplest one where someone owns a home solely to their name, they don't have an estate plan in place, I would say the cost for that would be between, probably the simplest one will be around $3,000. It could be more or less. It depends, for example, if you are selling the property through the probate process, or if you're just waiting to inherit it, to basically transfer it to your name at the end of the probate. And in very simple terms, this is what a probate is. This is actually the petition that has to be filed, like we talked about. Then we have to, the next step would be getting letters issued to someone, publication. Creditor is a big part of the probate because we have to notify all known creditors, hey, we need to pay you, give us your claims. We also have to publish for creditors, so if there are any unknown creditors, such as you didn't know mom had another credit card or some hospital bills or something like that. So the probate process could be, as you can tell, not only expensive, it is a hassle. You have to go to court several times. Usually it has to be done by an attorney just because the steps are pretty detailed and there's a time frame that you need to file things into. It provides a playground for creditors, for family members, for everyone to just come in, sit and hear your family's information, which sometimes the wrong kind of people get involved and they try to scam the beneficiaries who are mourning and they're in a very vulnerable state. So what can you do now? Ideally, you would talk to someone about having an estate plan in place. An estate plan doesn't necessarily mean a full-blown, fancy, expensive, extensive trust. It could mean just a simple revocable trust. It could be, in the right situation, a transfer on death deed. There are other ways that you can transfer real property upon death and avoiding probate, but there are lots of pros and cons to each one of them. So make sure you fully understand the consequences, because I often see people thinking that they're going to save their loved ones time and money by doing something themselves or by downloading a form off the internet, and oftentimes that causes more hassle than the time and money that it saved. So sometimes those work. Ideally, at least schedule a consultation with someone, see how much it costs and see if it's worth it to get your affairs in order and gain peace of mind knowing that your family will have it very simple, or at least as simple as possible when you pass. Our phone number is 405-857-8231. Our website is unitylegalservices.net. Give me a call, check us out. If you have any questions, I would love to answer them. If you have any ideas for future videos, again, I would love to have them, and I would love to record that and answer your questions. Also consider attending our in-person free educational events. We have them once a month. We offer lunch. We cover all kinds of things such as probate, how to avoid it, but also consider planning for incapacity, for a time when you cannot make decisions for yourself, or when you need a little extra help with your financial matters or medical decisions. Thank you for watching, and see you soon.